SJC-13219, John Doe v. Roman Catholic Bishop of Springfield.
Okay, Attorney McDonough.
Chief Justice Budd, may it please the court. My name is Michael McDonough on behalf of the appellants. This case presents three issues. Number one, present execution allows an immediate appeal. Number two, the Roman Catholic Diocese of Springfield is a charity, which is totally immune under counts 1 through 7 from tort claims arising in the 1960s.
Are you claiming immunity by suit or by of liability?
By suit, Your Honor. Number three, the remaining counts 8 through 14 are barred by the First Amendment, which denies civil courts subject matter jurisdiction over religious determinations. In this case, the Roman Catholic Church's determination of whether a bishop was, quote, credibly accused, unquote, as defined by Vatican-approved Catholic doctrine. First, present execution is a well-established exception to the rule that most appeals must await a final judgment in the trial court. However, the doctrine applies when the order interferes with rights in a way that cannot be remedied later and where the motion judge's order is collateral to the underlying dispute. Under the first element, the rights that cannot be remedied later are the defendant's absolute immunities from suit.
All right, let's talk about that immunity for suit for a minute. Are we dealing with anything involving the immunity statute, the charitable immunity statute, or are we concerned with case law before the immunity statute?
Prior to the statute.
So
in
we're dealing with the
1971.
common law?
That's correct, Your Honor.
All right, and where in the common law would you rely for the point that the church is immune from suit rather than liability?
Pre-1971 charitable immunity was an immunity from suit. As this court stated, immunity from suit is consistent with with public policy as to charitable corporations. That was footnote 17 to a state of Malton. And here there was before.
You read the exact quote, read the quote. You have the quote or you just do your summary of it?
Immunity from suit is consistent with public policy as to charitable corporations. And that would be footnote 17 of a state of Malton.
And what year was that case?
2014.
Okay, but that's not pre-immunity statute. I want something before the immunity statute that would have said that this is immunity from suit, not liability.
The question, we're not aware of a case that addressed that question prior to 1971. However, it's important to note that prior to 1971, and this is issue 2 in the case, prior to 1971, it was immunity from all torts.
Well, but don't the majority of our cases out of the common law hold that charitable immunity provides immunity from liability, not suit? That's how I had read them, that there were the cases before then in the common law doctrine were about liability, not suit. So I need something that says I'm reading this wrong.
No, we would disagree that cases or immunities arising from common law automatically do not trigger present execution. For instance, in Lynch versus Crawford, this court held where absolute or qualified immunity is provided by statute or common law, we discern whether the right to immunity is from suit or liability, because only immunity from suit, again, of course, entitles a party to present execution. Also, the Supreme Court in Mitchell versus Forsyth looked at the pre-existing common law basis for the public official immunity, and the Fourth Circuit has done the same in a recent case in which, again, the court has looked at what existed before. This court also did that in the 1980s in the case of Bro versus chairman of the board of the fire commissioners, a Springfield case also, in which the court looked at the existence of the law prior to Massachusetts adoption of the Tort Claims Act. There, the common law doctrine.
Does this tie in though to whether or not charitable immunity back then applied to intentional torts?
It does, and specifically this court, the appeals court analyzed that very question in a lengthy decision, looking at that question and studying all of this court's cases prior to 1971, and concluded that it would in fact cover intentional torts because it was an immunity from torts, not just negligence. And in fact, there was one
very different kinds of torts, right? Not child rape kinds of torts.
That's correct.
Yeah, very different kinds of torts.
That's correct. But here the defendant is not the individual perpetrator, but the charitable
Well,
corporation.
then we get to the second issue where corporation, what is the word sole?
It's a corporation sole, Your Honor.
Right, so
Yes.
it's a corporation in sole. And that means the person. And the person here is the bishop. And the bishop is one of the people accused of raping the kids, right? So I find it really difficult, if not impossible, to separate the bishop from the corporation in sole when the bishop is actually engaging in the misconduct himself.
So the corporation sole and the individual person, the bishop, are two absolutely distinct entities under the law.
How can, then no one's responsible? I mean, I don't understand. If the bishop is described as the person, as the corporation in sole, right? Read me the language, the definition of corporation in sole.
I don't have the Black's
But it
definition.
basically says whoever the bishop is of this Bishop of Springfield, right?
No, Your Honor, I would disagree. A corporation sole is a red herring in this case.
It's not a red herring when the bishop is described as the bishop in person is described as the corporation in sole. You can't, it's like sophistry to try to distinguish those two.
No, Your Honor, because it's the same thing as a corporation aggregate, which would have perhaps a board of directors of 4 directors. Here, it's just a one-man director. And so if the 4 directors of a nonprofit, of the Red Cross, went out and drove their car off duty and crashed it negligently, Red Cross wouldn't be liable if all 4 of those directors were involved. It's the exact same legal
That's why
principle.
corporation in sole is different because it's one person.
That's right.
If we're going to take this, then no person's actions can, then the corporation has no responsibility for anybody, in your view, because that person is the corporation, but we're going to ignore all that person's actions. Just
No, if those actions are within the scope of his,
but there's no one, under your view, then no one will be responsible for the corporation. If when the only person who is the corporation in sole is not responsible for the corporation, how do we find anyone responsible? No person can act for the corporation in your view.
the analysis would be, were the actions in furtherance of the corporation within the scope of the duties of this corporate officer, or multiple officers in the case of a board, or one officer in the case of a corporate sole? And here, all the activities are well afar and cannot be well afield of the purposes of the organization as stated in the statute forming it, which was cited by the plaintiff in his complaint, which was for charitable purposes to conduct religious activities on behalf of the Roman Catholic Church in Western Massachusetts.
What about the Fells Acre, not the criminal case, the civil Fells Acre case? That I think it's, even though it's in the context of insurance, talks about the responsibilities of the corporation when there was a sexual abuse allegation. Why wouldn't that reasoning apply here to the corporate sole?
Fells Acre found that the activities were outside of the scope of authority, and the same should hold here. That these activities, for example, if the board of
But they talked about the possibility in that case that it could have been part of the, perhaps on further development or in different circumstances, actually part of the practice of the corporation and to serve its purpose. That was raised in the case, right?
It was, and in this case, the motion judge rejected that argument, saying there could be no inference that the general practice of the entity was the sexual abuse of minors. These actions occurred by individuals outside of and apart from their duties as religious leaders. And because of that, they cannot be drawn in. Most notably, the restatement of agency.
If we take that to the logical conclusion, I just want to make sure I understand it. Does that mean no, the church is never responsible? In your view, and I'm accepting what you say, okay, if any individual is acting for non-religious purposes or non-charitable purposes, the church is not responsible, right? That's your argument, right?
If it's outside of the scope.
Right. So all of that, if we take that to its conclusion, right, that means all of the sexual abuse of kids at that bishop must necessarily, the the bishop has no responsibility for it, under your view, right? If every single priest was doing it, the bishop would have no responsibility under your view, right?
No, currently we're under a different law right now, but prior to 1971, with absolute charitable immunity applying,
But let's go back to that absolute charitable immunity again. Do you agree with the fact that if it is immunity from liability and not suit, that present execution doesn't apply?
if that's the determination of this court, but that would be inconsistent with the court's holdings and what the Supreme Court held in Mitchell v. Forsyth, looking at total immunities. This before 1971 was a total immunity. Now, plaintiffs always had the ability to sue the underlying tortfeasor directly. That wasn't done here. They couldn't sue the charitable employer of the tortfeasor, and it's alleged that all of those actions occurred in the 1960s before the law changed.
But what you're saying, though, is under past law, the church would have no responsibility. The individuals alone would be responsible.
That's correct.
And now, under current law, with a cap, are you saying then that the church would only be responsible for up to $20,000, whatever the cap? What is the cap now?
It is $20,000.
That what so for all of this activity, the only people responsible are the individual priests, and the bishop prior to the passage of the act is not responsible for anything, and post it's only responsible for $20,000. I'm just trying to summarize your argument. Is that right?
That would be applying section 231.85K.
I don't find that somewhat disturbing.
That is what the legislature has enacted. And this analysis, again, is a pre-1971 analysis. Moving to the third point.
Post 1971, the only difference is the bishop is exposed to $20,000.
The corporation, not the bishop, Your Honor.
That's what I'm saying. The bishop and the corporation in sole is responsible for $20,000.
That's correct.
That's the cap for all of this.
That is the cap. Yes, Your Honor.
Again, you think that's what the legislature intended?
I do think that the legislature.
For all of this activity, you think that's what the legislature intended? That's a harsh judgment on the legislature.
It has been analyzed as a continuation of the trust theory. And again, none of these counts arise under that fact pattern. These are pre-1970s counts. Moving on to the third point, if I may, counts 8 through 14 invoke or make tortious actions that the church and its employees and volunteers did. Now, moving forward to 2014 to 2019, not by anyone accused to have committed any physical abuse, but those working under the church's Vatican-approved guidelines and polity for helping and ministering to
but
abuse.
that's where the claim is, right? In implementation of that policy, correct?
Yes, Your Honor.
So the challenge is hey, you didn't even follow your own policy for how to deal with this. So you're claiming that this is, what's the phrase again? The autonomy doctrine, the church autonomy. How does that work?
It's the religious autonomy doctrine under the First Amendment of the Constitution.
Right.
And under Hosanna Tabor, the Supreme Court said, even if a religion didn't follow its own rules, civil courts do not examine or re-examine the issue. It's the same as this court's decision in the kosher cases, including United Kosher Wholesalers versus Associated Synagogues, where they said that the rabbinical board had frozen them out by declaring them non-kosher. This court said, even if you're alleging that conspiracy, that your competitors have donated to the synagogues and you haven't, and now they're freezing you out, even if that looks like it has merit, we will not intervene. There it was, what is kosher was going to decide that case. Here it is, who is and how is a clergy member, quote, credibly accused? Not the layman's use of those words, but the Pope's guided use of those words under Catholic canon law, which this court, the Supreme Court, has said may not examine.
So because, oh, go ahead.
No, go ahead. Go ahead.
Because the complainant's complaint alleges things that use similar language to the Pope's order on how you're going to handle this, this brings it into the religious doctrine?
That, and in addition to that, Your Honor, the plaintiff was voluntarily participating in that religiously created program for 5 years, and then disagreed with the religion's findings of a religious board, the review board, as it's following its procedures under the Dallas norms, which is enacted by the Vatican and the U.S. Conference of Catholic Bishops. And I encourage the justices to read those norms because they control every act that has been deemed tortious in counts 8 through 14.
That's in your record appendix, right?
Yes, it is volume
Okay.
2.
I have one
page
other
119.
question, and that is this church autonomy doctrine a jurisdictional issue, or is it an affirmative defense?
It is a matter of subject matter jurisdiction, whether the court has the ability to review this. And it even includes a religious institution's commenting and public
How
commenting.
many cases that say that this kind of thing is a jurisdictional issue?
Yes, I think under Hiles and Petrel, this court has said that. And there in Hiles specifically, that religion held a press conference deeming the aggrieved party from the religious tribunal and how bad their actions
Didn't
were.
Hiles distinguish? I understand there may be, you may be right that there may be some pruning based on complaints about how the internal process of the church dealt with things. But Hiles drew a distinction once they made public statements, and they could impose responsibility once they went outside of the process, the church went outside of the process, that could be subject to liability. Isn't that what happens here when statements are made to that reporter?
No, because the Dallas norms require the church to publish its findings publicly, even in the secular community. And they require the communications director of the church, the actor here, to hold objectively and give due process to accused priests who have not yet been termed, quote, credibly accused. He had to answer it that way.
Again, I want to push you on this. So if the Dallas norms require public statements, does that mean the church is immune from any kind of liability for anything it says, so that it can act with total impunity? I don't know if this is true or not, what they said to that reporter, but say it's a out and out lie and they know it. Is because the Dallas statements require a public statement, they're now protected?
It depends on the statement. If it's about whether a clergy member was or was not credibly accused as defined by the Vatican and the Dallas norms, that is protected. If, however, the spokesperson said, by the way, this individual, he's murdered 3 people, he's committed these frauds, that would not be protected. That's way afield of the disciplinary system and abuse victim support system. Same thing as whether the rabbis were lying about whether the business was kosher.
So wait. So if a priest commits a murder, then that's not under the religious exemption, the what is it called again? I keep losing this phrase, the religious doctrine, right? It's not under
This
that.
autonomy doctrine.
Religious autonomy doctrine. But if a priest rapes a child, that is under the autonomy doctrine?
No, pardon
What are
me
you
if the
trying to
example
say?
was unclear. If the comment about the plaintiff was that, oh, this plaintiff has not alleged or his finding has not resulted in a finding of credibly accused. If they made statements about the plaintiff having nothing to do with the process, of course, that would be non-protected. But they are required on the Dallas norms to inform the press, and this is a list of publicly accused priests, and this is why the press reporter contacted the diocese was, why isn't this bishop on your list? The answer was, under the Dallas norms, he's not yet, quote, credibly accused. And there has been no finding of that because the Pope dictates only the bishop can make that finding, and we're not there yet.
But, okay, so when you say we're not there yet, what are you talking about? Are you talking about the internal process of the church? Are you talking about the process of this lawsuit?
The process of the church. So first,
So we have to wait for the church to resolve all that?
the church's system, it operates under its own timeliness and its own
Right,
procedure.
and so the civil system just waits for that?
The individual can always, from step 0, and the church informs them, sue anyone, go report to the
Yeah,
police on
but
day
I want to
1.
know what to do with this motion to dismiss now on counts 8 through
Oh.
14 on the religious, the religious autonomy doctrine. Where is the religious autonomy how does that play out, and how does that relate to your doctrine of present execution?
The way that the Supreme Court has, and the case law has played out is that the individual can appeal within the religious system. And here the church did reinvestigate everything in the Vilas report that is cited in the complaint. And the church ended up agreeing with the plaintiff and listed
Okay,
this
so
there.
what does that have to do with the doctrine of present execution?
Because here, that First Amendment protected process,
Mm-hmm.
when someone disagrees with the timeliness or the way that it was implemented, cannot take that conduct and turn it also into a civil tort and then sue based upon it. And so a religious defendant should not be forced to face the burdens of litigation, and it's a violation of the First Amendment.
But can we just talk about that in a little more detail? Because I certainly understand your argument about the review board and the internal process of the church and the First Amendment. And even perhaps on comments as it relates to credibility. But when somebody's out there spinning and saying, oh, and by the way, he retracted that, or he never said that, that's just spinning. That's not religious doctrine. That's not what happened with the review board. And there's contentions here that some of the statements are, well, yeah, he acknowledged that there was no abuse. That's not review board. That's just trying to get a good soundbite in the paper.
Again, though, that analysis is stepping into how the church interprets the evidence before its board. And specifically, the plaintiff in this case alleged in the complaint that, in fact, the investigator did have a report that said that the victim did recant as to this third cleric. Remember, the church immediately found credible the first two clergy members that were accused. The confusion was over the third. And then the church did reinvestigate that after the press response. It took a year-long investigation and ended up siding with the plaintiff. Also, on disparaging comments, the plaintiff was never named. His anonymity was kept in all of these comments to the press. So a defamation claim without even naming the intended or the defamed person, and again, the norms require the name Weldon was shared. And at that time, there had not been a finding of the quote credibly accused or a kosher determination or a determination of another religious board. Here, they hadn't made that determination yet. And reviewing the church's review of its own evidence through its process, forgive me, but the plaintiff's complaint is asking this court to trade its judicial robes for the vestments of a bishop or a pontiff and to reinterpret these doctrines, which the First Amendment, the Supreme Court, and this court have all held it will not do, even if it sees an aggrieved party and perhaps otherwise a meritorious claim based on the complaint. It will not do so because that calls into question separation of church and state, which we find fundamental, going back to the Adams Constitution, duplicated in the federal Constitution, and upheld in Piles, Petrel, and the many First Amendment cases of the Supreme Court. This program also provides therapy payments, medical payments, payments for compensation, which is under the religious program here. And it's perfectly fine for the plaintiff to go there and report to the police, as the diocese here in the complaint and in the Vilas report attached to the complaint did forward everything in 2018 to the district attorney's office. However, when someone is upset with the outcome of a religious board, they cannot go sue the religion for the timeliness with which it came to its decision, and the decision
That's not what's going on here. What's going on here is whether counts 8 through 13 should be dismissed, not because they're going to litigate what the review board did, but they have to be dismissed even though there were statements made to the press that didn't relate to the mission of the review board, but were commenting on statements that the victim allegedly made. And it's not whether that it falls into it or doesn't fall into First Amendment protection. It's that you're saying, no, 8 through 13, they're dismissed. It shouldn't be litigated whether or not those statements exist.
That's correct, because the religious guidelines here on Record of Appendix Volume 2, it's 119 through 138, and specifically page 129, provides that the religion or the diocese here must communicate its findings to the press.
What if it said you must yell fire in a crowded theater? You can just have anything in there that eliminates a defamation to it?
No, that would cross over into the conduct cases and analysis. Here, it's simply, and in Hiles, the religious group there, the Episcopal Church, went out on their own and held a press conference and said the misdeeds of how bad the actor was in that case, and then was sued for that defamation. And this court said it is perfectly natural for a religion to inform the community on discipline concerning its senior members. And in the Catholic Church, discipline survives even death. This individual was exhumed, his body was moved out of state, monuments were taken down, a hospital named after him was renamed. The disciplinary process, people are canonized and disciplined even after death. This is a disciplinary process. Disciplinary systems have always been found to be protected and even comments on them, as this court said in Hiles. Again, here, just response to a reporter. Hiles, an affirmative press conference describing the immorality in the findings, not defamatory, even alleged when to be conspiratorial. There was $1 million bequest to that clergy member's church. And he said, this is all fixed to take it up to the diocese. This court said, we're not going to get into that. We're not going to examine whether it was a right or wrong determination. Even if we can read your principles and understand them clearly, we're going to follow the Supreme Court. We're not getting involved, just like in the kosher cases, the divorce get cases, Petrol and Hiles. We will not embroil this court in matters when there's any ecclesiastical concern. Unlike a property dispute, here, this is a disciplinary system and it can't be re-examined. For that reason, counts 8 through 14 should also be dismissed, and the decision of the motion judge should be reversed. Thank you.
Thank you. Attorney Pelletier.
Morning, Chief Justice Budd, members of the court. I'm here on behalf of John Doe. I'm going to begin with the premise that one of the justices raised, and that is that according to the defendants, the issue involving religious autonomy, they perceive to be one of subject matter jurisdiction. This court has said very clearly that the issue of subject matter jurisdiction is not subject to interlocutory appeal, even after a summary judgment record has been developed. Certainly, the very limited doctrine of present execution should not apply under the circumstances of this case when they are alleging that the issue is one of subject matter jurisdiction. Frankly, that should end the inquiry because
Don't we have to wrestle with the issue of whether it's immunity from suit or immunity from liability? Because if it's immunity from suit, then it would fit within present execution doctrine. right?
that's the first series of claims. I'm referring to the second series of claims, which is the religious autonomy portion. And if the second set of claims, those related to the communications with the press, are subject to subject matter jurisdiction arguments, which is their argument.
Mhm.
Once that determination is made that that portion of the complaint is not subject to the doctrine of present execution, the diocese will remain in the case and the case will proceed. And under those circumstances, rather than foster, it would foster piecemeal appellate litigation rather than restrict it. In terms of your inquiry on the first, what I'm calling the first set of claims, there is no suit. There is no case anywhere in the Commonwealth that addresses the issue of the common law determination of charitable immunity in a way that would suggest that it's immunity from life.
He read a footnote. I don't have the footnote in front of me, but he read a footnote that talked about immunity from suit, didn't it?
He read a footnote that talked about immunity from suit, I believe, referencing not a situation such as this, in a situation that postdates chapter 231, section 85K.
So it's loose language that was wrong. Is that what you're saying?
I'm saying it's a footnote in a case that has no application, frankly, to the issue of common law immunity under the circumstances that we have before us. And as I believe you noted, the concept that this common law immunity would be so global as to apply to the circumstances of this case, also addressing the issue of intentional tort, is extremely questionable. But it has not been decided.
Well, the SJC has not decided whether the intentional torts would fall within the pre-1971 immunity, right?
That's correct. Any intentional tort, never mind the types of torts that we're talking about in this case.
The second issue they raise is more complicated though, right? There's a lot in the complaint that's caught up with the internal disciplinary process and timing and, back and forth. Don't they have a point that some of that is beyond our jurisdiction and will get us excessively entangled in the church disciplinary and investigatory process?
No, because the complaint contains the detail of what happened at the review board process so that you can understand what happens thereafter.
But
The-
again, it looks like it fits within what Hiles talks about, which is we don't want the civil courts to be caught up in policing the internal. You can go to the civil courts and, I find the first part of this not without basis. You should be able, if priests are raping, children, the civil courts can investigate those and prosecute them and hold the bishop liable. That part I don't have any trouble with. The second part, though, they seem to have a pretty good point, which is we don't want the civil courts reviewing how the church's own processes went. That's separate. We should stay out of that.
I don't disagree. I think the problem is the analysis that that's what the theory of liability is. The theory of liability in this case is not with respect to what happened at the review board itself, but what happened when an inquiry was made. And this is different than them going out and presenting a press conference. An inquiry was made by an outside individual as to what happened and why certain things weren't done. The response to that inquiry was documented in emails. The response to that inquiry is where the defamation lies, not in what happened.
But again, it's based on what's going on in their own processes and whether they're telling the truth about their own processes, I guess. But it seems like Hiles seems to cover that, though,
Well,
doesn't
the
it?
process had theoretically been completed. The process had been completed as far as they were concerned. There was a letter that was written by the review board, and I believe in the letter itself, the chairman says, we're done. Now this goes to the bishop.
Right.
And then it was done as far as the church was concerned.
But let me, along these lines, where I'm getting a little bit confused on this is that you basically have two types of statements, right? That Doe's basing counts 8 through 14 on. One is the statement regarding the findings of the review board. And then the second one is the statements regarding the substance of Doe's allegations. And it seems what I'm struggling with is that this first class would seem to require that we determine whether that review board made a finding, in which case we would be rendering an opinion on what the board did or didn't do within their own processes.
The review board wrote a letter that was very simple. We're not asking the court to consider what the review board said. There is a letter. And it is very simple. And that is what was given to the bishop. That is what is before the court. The efforts now to say the letter doesn't say what it says is essentially attempting to change the terminology in the letter. But the letter is there and the letter is evidence. Add on to that the fact that the church itself engaged retired Judge Peter Vilas to conduct an investigation, and he made a determination which was adopted by the church and adopted by the bishop, which clearly says that Bishop Weldon was credibly accused.
I'm looking at paragraph 40 in your complaint. Defendants owed or assumed duties to report plaintiff's allegations, that part's easy, properly investigate the complaint, accurately document their investigation. That seems problematic. Refrain from falsifying or altering the documentation relevant to their investigation, accurately convey the results of their investigation, refrain from misrepresenting allegations, results of their investigation to the public and the press. Isn't that what we're not supposed to get involved in? Because it's like redoing it's basically talking about how they did it and how they described it. That seems like that's Hiles, but why am I wrong there? I just don't get it.
Again, because I suppose there's some language in there that might be problematic to the extent that it purports to suggest that.
Well, isn't all of that what I just read problematic?
Not in my view, Your Honor, because again, we're not talking about the process itself, which according to Judge Velas wasn't followed.
But you are talking about accurately document their investigation. Refrain
that-
from falsifying or altering the documentation relevant to the matter.
That,
Accurately convey the results of their investigation. It seems like it's all about their investigation.
to the extent that the term investigation is utilized, a portion of that relates to what happened, and perhaps investigation is not the proper term, once Mr. Parnas made his inquiry. There was then an entirely separate scenario which involved counsel. It wasn't the review board. It was counsel, the director of communications, the director of safety for the church. It was a new person. They allegedly conducted some form of investigation so as to allow them to respond to the inquiries of Mr. Parnas. That's completely independent of what happened at the review board, and nowhere in their,
Well, Mr. Parnett, is he the reporter from the
Yes.
Berkshire?
yes,
paper? He wants to know what the church has found about the
Right.
bishop. He may have a business in that, but the courts we don't create liability out of that, right? Because we want to keep ourselves separate from their investigatory processes. I mean, the reporter may want to see whether they're living up to their own terms, but that's different than the civil court system, isn't it?
I think there's a separation once they begin to respond and create a false narrative.
But doesn't Hiles say the exact, I mean, I may be misreading Hiles, but I just went back to it. Doesn't Hiles say the exact opposite? They can make statements about it, and they can even make untrue statements about it, right?
In this situation, in response to the specific inquiry and making statements which are defamatory as to Mr. Doe, which is what they did. If they simply said, no, that isn't what we found.
But isn't that what Hiles said they can do? Maybe tell me why am I misreading Hiles? Or are you saying Hiles is wrong?
I'm not saying Hiles is wrong. I'm saying that this takes one step beyond,
Why?
because it's outside of the process that they,
Hiles' statement is also outside of the process, right? Didn't they, in Hiles, don't they make some kind of potentially defamatory statement outside of the process? I don't remember in detail.
I don't think it's outside of the process the same way that this is, even assuming
It's
You
a
can
statement,
figure out what
it's a
the pro-
statement to a reporter, isn't it?
it's a statement made from the church out as opposed to in response to an inquiry.
So
And I
that,
think
to
there's
you,
a-
that's the big difference that
Well, I think
one's,
there's a distinction to be made. They weren't, the cases where the diocese, through its communication director, puts out information, arguably falls within their process. But in response to an inquiry from the outside,
the inquiry is about their process.
well, but that would mean that anybody that asked a question about anything that goes on,
No, the reporter is free to ask the question. The reporter is free to call him a liar and do whatever he or she wants. The question is, do the judicial system create a remedy for that?
and our position is, yes, it does, if you get to that level. But again, I'm going all the way back to the issue of whether this is an issue of subject matter jurisdiction. We wouldn't be addressing this at this point because it shouldn't be before this court under the doctrine of present execution. The court has no further questions.
Everybody else set? Thank you very much.
Thank you.